All rise. 14A District Court for County of Washington, State of Michigan is now back in session.
You may be seated.
Not that I'll get my
Yeah, I know where yours is.
I did call it yesterday.
that we're back.
Call.
I did it. Did it.
Here we are back on the record in the cases of the People versus Couch, Gates, and Matthews. Closing. Yes, sir.
Your Honor, in this case, the people would agree that there is not a definitive statement from the victims as to these defendants being the individuals that perpetrated this robbery. But I believe that when the court considers all the evidence taken together, the court can find by probable cause basis that these are the individuals who are alleged to have committed these offenses. Beginning with defendant Matthews, we know that he was there at the time that this robbery occurred based on his tether, and while opposing counsel argues the tether can't place him exactly there, the court has the map showing the GPS location that the tether was in the house. The court also heard testimony from the victims that one of these robbers had a tether on him. So I believe by at least a probable cause standard, the fact that we have an individual on a tether where this defendant's tether shows he is doing this robbery, that leads us to believe that he is the one participating in this robbery, and that helped facilitate this. We know that Myron Couch was with Matthews based off of his own admission during his interview with Detective Sergeant Morrow. He tied himself with Matthews and said he was with him. We also have the cell phone record showing that he is near the area of the venue a little bit before and after the offense, consistent with the GPS tether data of Matthews. Specifically at 7:56:53, and this is on page 5 of Exhibit 13, the court can see that that black arc shows Myron's phone in the same area as the...
Which page?
Page 5, the tri-picture one. The court can see Myron's phone receives a call at 7:56:53 that appears to be consistent in the rough area that the GPS tether indicates Matthews going towards the address. There is also the evidence that Christy
in
Couch
Michigan's
rented
14A District
U-Haul that
Court.
was...
Judge Simpson, open session, conflicts waived, lawyers, spar, and the case of People versus Gary. Chase collapses when a sick victim cannot appear. Dismissed, but not forgotten.
Suspect vehicle in this offense, and the court can see from the flock images, especially on the next page, showing her vehicle traveling directly behind about 33 seconds after the U-Haul is leaving the scene at 8:32. It's also evidence that she was aware of and helped facilitate this based off of the...
How does that get me there?
So, Your Honor, the fact that she rented the U-Haul and her vehicle is traveling with the U-Haul, I believe goes towards knowledge or her working with that U-Haul. Considering her earlier claim, I believe that she stated to Detective Sergeant Morrow was that she rented it so that way Myron could help the sister move. I believe that this goes against that. She's traveling with it after leaving from this incident. I also believe that the court should consider the Cabela's footage where she purchases 3 identical camo shirts, and the victim testified that at least one of the individuals was wearing a similar shirt and those were purchased the day before the offense. I believe the court can.
I go to my house, I got 3 camo shirts. I don't know what that does for me.
So, Your Honor, I believe that it shows that typically, or let me rephrase this. When we consider that she bought clothing that appeared to be consistent with some of the clothing worn by the individuals that perpetrated this offense the very next day, she rented the U-Haul that was near that address and was leaving that address the next day. I believe that that can show that she helped facilitate this and helped prepare for what was going to be this robbery, providing a vehicle, providing clothing, and then also following behind and remaining in communication with Myron Couch beforehand and afterwards. And we can see from Matthews' tethers that he goes to the Couch's address afterwards as well. So I believe all of those things, when taken together, provide at least probable cause to believe that Christy Couch.
Do I have Christy Couch's phone data in the area?
So we have on the page 5, again, we can see that she made an outgoing call a little bit south of the area. We don't have an exact number. As I believe Ms. Zielinski testified, we're not going to have an exact location, but we do have that 7:56 call before the incident occurred. She is somewhere south of the venue where it occurred. And why I think that's important is if the court recalls her statement to Detective Sergeant Mora that Detective Sergeant Mora testified to, she claimed to him that she had left her house and begun door dashing. I believe it was 8:30 to 9 o'clock that morning, when her cell phone shows that that was not the case. And I believe that also casts doubt on her statement. She rented the U-Haul for the purpose of facilitating this move with Myron's sister.
But I don't have her at the address.
Correct, Your Honor, and I will agree. She is not directly at the address, but our theory is that she helped plan and precipitate this by providing the U-Haul, providing the clothing, and working with it. If not necessarily at the venue, I believe that she was still aiding and abetting and is liable under that theory.
How close do you put her to that address?
Your Honor, I don't know if I can give an answer to that. I believe that the testimony is that we can't give an actual location based off the cell data. But if we consider the flock data, we can see her, we know that she was to the south of the address at some point close to 8 o'clock that morning. Then looking at.
I know that her vehicle's there.
Correct.
I don't know that she's.
And I'll perhaps rephrase it. We know that her cell phone was to the south of the area at 7:56:39 that morning, and we have the camera showing her vehicle leaving that area at 8:30, traveling up with the U-Haul, and then eventually heading back to the Couch's residence. I believe reaching there about, it looks like 8:40 is when the tether from Matthews shows it, and we have camera and calls from about 9:40, so an hour later. So I believe that the evidence taken together shows that she is working with this robbery, if not necessarily physically present at the venue herself. And then finally, for Defendant Gates, I believe there's probable cause to believe that he helped with these events. And for that, I would direct the court to the cell phone records for Gates's phone as well, where we can see he was with, or his cell phone was near Defendant Matthews' location. And the last outgoing activity is 9 seconds after 7 o'clock is that last, or sorry, 1 second after 7 o'clock is that last call. 6 minutes later, we see Matthews' tether going down. And it's not until about 1 minute after Matthews' tether returns that evening at 4:10 that we have an outgoing call from Gates's phone. Now the court can see from, well, strike that. There's reason to believe that Gates was with Matthews because we have the prior activity that's suddenly
with Matthews.
I'm sorry, I didn't hear the court.
What puts him with Matthews?
So, Your Honor, the fact that his phone ceases activity as soon as Matthews leaves and then resumes activity as soon as Matthews begins leads to a belief that the phone was left at the house while he went with Matthews to precipitate this robbery. And I would again remind the court that there were
Not his phone at the house.
Yes, Your Honor.
So there's no activity from his phone.
There was no outgoing activity, I believe was the testimony. I believe there was still incoming and the phone was receiving.
Okay, so, so I'm supposed to assume that he left the phone because where his phone is inconvenient for the people's theory.
Not necessarily because it's inconvenient, but I believe that there.
Everybody else, though, I'm to assume they're with their phone, except him.
And Your Honor, I believe that there's evidence to support that because we can see at 7:14 as Matthews and the people's position as Gates as well are traveling down. We know Matthews at least is traveling based off of the tethered data. His phone disconnects at 7:14, so it shows an effort to remove oneself's phone from the network. And if defendant Gates was with defendant.
She recalls her father's gun tucked in, his waistband, his spit inches from her face, his voice booming. Ordered to her room. She fled terrified only to be grabbed.
Matthews, as the people are putting forward, that makes sense that they are acting in concert. And
That's double speak. Everybody else, just answer me this. Everybody else, with the exception of Mr. Matthews, who had his own little radar thingy, everybody else, I'm to assume that where their phone is where they are, right?
roughly, yes.
Except Mr. Gates. Because I'm supposed to assume Mr. Gates is somewhere other than where his phone is.
I believe the short answer is yes, Your Honor.
So how does that work?
Because, Your Honor, when you consider the types of activity for the other defense, we have those outgoing calls that shows activity being made from that phone. Whereas Gates' phone, there's only that incoming that shows that there.
So if Gates took a nap and doesn't answer his phone, I'm to assume he's with the rock.
Not just based off that, Your Honor. I believe that the court can find that also based off the testimony that there were these 4 individuals that were in the house. So we know there's multiple individuals.
Okay.
We know.
I got 4 supposedly African-American males in this building. I only have 3 here.
Correct, Your
So
Honor.
that doesn't help me, does it?
I believe it shows that it is possible for him to have been there. And the fact that it's at Matthews's house.
I got more than just possible. That's not. The reality is, I have nothing that puts Mr. Gates there. Except speculation.
I would agree that there's only circumstantial evidence, and while it's not as strong as the other.
Evidence. I have nothing that puts Gates there except speculation. Because it might be one thing to assume that the person is with their phone. I have to speculate that Mr. Gates left his phone someplace and was just traveling without his phone in order to put him there. Don't I?
I believe, yes, the court would have to make that assumption. But I believe, Your Honor, when compared to the alternative being that he just didn't have any activity until Matthews shows up and then he has activity, I believe that's also.
But I got to put him there.
Understood, Your Honor.
Okay, go ahead.
Ultimately, as I stated, this is, I believe, a case of identity where I did not hear much argument about the facts as far as what happened during the robbery being in dispute, but rather that these individuals were ones that did it. I believe that we have good evidence showing that defendant Matthews was there based off of his tether, based off of the statement that an individual wearing a tether was there. Believe that there's ample evidence to, at least by a probable cause standard, find that Myron Couch was there based off his relation to the family member and the belief that he owed money. These individuals come in asking, where's the money? It's clearly a monetary goal originally, as well as his statement that he's with Matthews, I believe is probable cause to believe that Myron was there and committed this offense. I believe there's probable cause for Christy Couch to have helped in the commission of that offense, and under the aiding and abetting theory, providing the tools to commit this, at the very least the U-Haul and the shirts, that goes towards that And we have already
But one would have to knowingly do that, correct?
Yes. And then we had the discussion regarding Mr. Gates, and so I don't believe we need to rehash that discussion. But for those reasons, I would ask
I
the
don't want to, but hey, let's go back to Mrs. Couch. Tell me everything that puts her there or says she was aiding and abetting.
So beginning sort of chronologically, we have her assisting with the purchase of the clothing at Cabela's, the 3 identical pieces of camo shirts. The victim one of the victims identified at least one of these robbers to have been wearing similar identical clothing. We then have her renting the U-Haul that was used during the commission of this offense. We then have her vehicle following that U-Haul. We know she was in communication with Myron, who, as I've already argued, we have reason to believe was there.
Her husband.
Yes. And then afterwards, we see them again traveling away from the location in close proximity to one another. We have her statement.
How do we have them in close proximity to each other?
So on the flock cameras, we see the U-Haul as well as Christie's vehicle. And
Hold on. You said though, we see them traveling away.
And I should be more clear, Your Honor. I do.
Yeah, you really should, because I don't have we anything. So we see who? What do we see? What are you telling the court?
We see the vehicle that Christy Couch rented.
Next case, People versus Victor Bullard. His daughter testifies he grew angry, stormed upstairs, and cornered her. The defense denies harm. The courtroom waits, breathlessly as truth and lies collide.
Being the U-Haul and the vehicle that Christy Couch is the registered owner of, driving away from the venue shortly after the 911 call was placed. We also have Christy Couch's phone near the venue to the south.
With the evidence you've given me, isn't it equally as plausible? Because he admitted that Mr. Couch is in the white van.
Yes.
That the other defendant, Mr. Matthews, is in her car.
That is a possibility, Your Honor. I believe that's a question for the trier of fact.
Okay. Go ahead.
Your Honor, I believe I've made all of my points. I have no further argument. Thank you.
Any additional response from Mr. Couches, Mr. Norman?
Your Honor, I would just, there was not any testimony linking Mr. Couch. I don't even think that anyone was able to testify that the van that was in the driveway at the home that was seen, no one could ever make the connection that it was the same van that was running around.
Oh, I think they did.
They did not. When asked whether they could see any identifying markings or anything from that vehicle, all the testimony was no.
Okay.
And again, Mr. Couch was not identified.
Except he puts himself in the van. But anyway.
Very
Mr.
briefly, Your Honor. Mr. Cook said several times that there was evidence of my client purchasing, quote unquote, the camo. There was no such evidence. With the video showing her at the U-Haul place clearly was identified by a witness as being my client. Nobody identified her in the video. That's a sort of wishful hope by Mr. Cook. Second of all, nobody said that was the same camo. They said it was similar, not the same design, similar. And number three, when I asked the witness with regard to the pictures of the flock pictures of the van, how close were those, or where were those in relation to where the incident took place, she couldn't answer. We only have his argument that they were leaving that location. There was never any testimonies to that.
Mr. Bernstein, any additional?
No, Your Honor, thank you.
Mr. Brown.
Well, Your Honor, when the weapons that were allegedly the firearms were found were never attached to this case in any significant way. The prosecution asked the witness if found any evidentiary value. I would say that the firearms are not of evidentiary value, in that they haven't been associated with this incident at all. I just wanted to put that out there.
Court's gonna stand in brief recess.